Hi, everyone. My name is Ava, and I work in the Center for Community Engaged Learning at the University of Minnesota. I'm going to pass it off to Laurel to introduce herself.
Hi, everyone. I'm the director of the Center for Community Engaged Learning and co-hosting this event tonight. Maddie.
Oops. Hi, everyone. I'm Maddie. I use she, her, hers, and I am also helping plan this event and work in the Center for Community Engaged Learning as well.
My name is Malika Ava, and I use she, her pronouns. I work at the Legal Rights Center. We're a nonprofit public defense firm representing young people and adults in Hennepin County Court. I'm a social worker by trade, and I'm the community strategy lead at the LRC. Glad to be here with y'all tonight.
Thank you, everyone, and thank you especially to Malika for coming and sharing her expertise with us, as well as her expertise in restorative processing, which is what we're going to do during the second half of this event. So as some of you know, this is another event in our Ways to Social Change series. As with our other events, we have taken some sections from the Social Change Wheel, which is a tool from Campus Compact that helps encourage students to get involved in community engagement. And our theme this month is Learn, which includes the sections of the wheel that are raising public awareness about a social issue, deliberative dialogue, socially responsible daily behavior, and community-based research. So our event today will focus most specifically on deliberative and reflective dialogue, but we'll also touch on raising public awareness about a social issue. And as Malika said, we're joined by the Legal Rights Center, a Twin Cities-based nonprofit who focuses on criminal defense, restorative justice, and legal education. So she is here to answer questions for us, as well as to lead us in some restorative processing. And she focuses most closely on the Youth Education, Advocacy, and Restorative Services program. So we're going to start with asking her some questions, and we'll open up the floor for everyone to ask her some questions. And then we'll move into those restorative processing rooms. So during our restorative processing circles, we are going to have a specific circle for BIPOC students who would like to process with other BIPOC students. So if that is you and you would like, our BIPOC student who would like to process with other BIPOC students, please go ahead and send me a private chat so I can assign you to that breakout room. And with that, I'm going to go ahead and turn it over to Malika to answer some questions about the trial and where we're at in the trial of Derek Chauvin.
Awesome. Thanks so much, Ava. Yeah, I'm super glad to be here to be able to talk about the trial. Though my background is in social work, I spend the entirety of my day talking to attorneys when I'm not talking to young people. And so in the way that in some people's homes, maybe like March Madness is on the screen in the background, the trial's on the screen in the background for our organization and our community. So I know that some folks had sent in some questions beforehand. I'm happy to just kind of open the floor and see if folks have any particular questions about where we're at with the trial, what's happened in these first 3 weeks of jury selection, and then any questions about what might be to come.
Oh, sorry. Go ahead, Michael.
Go ahead.
No, I was just going to ask if anyone wanted to start us off. So if you're ready.
Hi, how you doing, Malika? I guess the question I was going to ask is, as far as the jury selection process, one, have they completed the process? And two, what's the outlook of that particular jury pool? Is it fairly diverse, or are there going to be some challenges there?
Yeah, thanks for asking. That's a really great question, Michael. So as of today, as of this evening, we have a fully seated jury. In a felony trial in Minnesota, you need 12 jurors. And in this case, we have 2 alternates there. And those folks will be seated in the courtroom the entire trial. They'll be there listening, and they serve as alternates if any of those 12 folks aren't able to be a part of the deliberation at the end. At this point, it is a relatively diverse jury, especially a diverse jury for Minnesota. So I think the last time I checked a couple hours ago, there were 4 white men, 4 white women, I believe 3 Black men. Let me just look real quick. I believe, yeah, a multiracial woman in her 20s and one Black woman. That's probably not all 14, but pretty diverse for Minnesota. It is not uncommon for the attorneys in our office who are representing clients in criminal court to have all white juries in Minnesota. So I don't know. I think the diversity of the jury could be a potential positive sign for folks who are looking for a conviction in this case. But we have to remember a couple of things. The first is that in Minnesota, jury decisions have to be unanimous. So if a single juror decides in an opposite way, it's in this case, particularly, they decide that Derek Chauvin would be not guilty for the charges for which he's charged, then they don't have a unanimous decision. And so that can certainly be a challenge. And then the second piece too, that I keep telling people, I keep telling young people that we're working with especially, what the jury is being asked to do is incredibly challenging in this case. The legal standard that they're being held to, proof beyond a reasonable doubt, is one of the highest burdens that we can have in a criminal case. And it's to say that they have like no reasonable doubt in their mind that he could be not guilty. I think actually we have a video queued up to explain that, which is, just a great transition on my part, if I do say so myself. But maybe we could show that video and then go into other questions too.
Okay, let me know if you guys can hear it once I start it.
Burden of proof. There are two ways lawyers can prove something in court. The first way is through what we call direct evidence. Direct evidence is evidence that clearly shows a person or group of people has committed a crime. The second is by offering circumstantial evidence. Circumstantial evidence doesn't directly and clearly show the person must have committed a crime, but instead shows that this person could have committed the crime.
Now let's talk about what burden means. In a legal case, the burden refers to who has the responsibility to prove the evidence of the crime. In all criminal cases, it is the responsibility of the prosecutor to prove that someone is guilty of a crime. And just like there are different types of evidence, there are also different types of legal burdens. And these different burdens of proof can be thought of as obstacles that prosecutors must clear in order to win their side of the case. You might think of each of these burdens of proof as hurdles. Some burdens are easy to prove, and those hurdles are shorter and easier for a runner to jump over. And some burdens are harder to prove, and those hurdles are taller and harder for a runner to jump over.
An example of a very short hurdle is probable cause. This is a very low burden of proof. Probable cause means that there is a reasonable basis to believe that a crime may have been committed. Prosecutors only need probable cause to charge someone with a crime. The highest burden of proof in our legal system is called proof beyond reasonable doubt. A defendant in a criminal case is always presumed innocent until proven guilty. In order to prove someone guilty of a crime and get the conviction, the prosecutor must prove beyond a reasonable doubt that the defendant did the act.
If a single juror has a doubt that's based on their own reason and common sense, then the state has failed to prove their case beyond reasonable doubt, and the defendant is found not guilty.
Thanks, Ava. I wonder if there are any other questions. Folks have other questions?
Just so I'm clear, if they're not found guilty beyond a reasonable doubt, is that considered an acquittal, and therefore they cannot be retried?
Absolutely. Yep. So that's where we're looking at. I think one of the questions that had come in earlier was like, yeah, what happens if Derek Chauvin's found not guilty? And the answer to that is like, that's where the process stops. The prosecutor, the state, is not able to try the case again. And so if he's found not guilty, then essentially he's acquitted of all charges. Some other steps that are happening in parallel. So folks may know last week, the city of Minneapolis, maybe it was 2 weeks ago, the city of Minneapolis did announce that they had come to a civil settlement with Mr. Floyd's family. So that's like one kind of parallel process that has already concluded. The federal government is pursuing federal civil charges against Derek Chauvin. And so right now, actually, they're like convening a grand jury, and I think bringing forth evidence in front of that grand jury for the potential to have him indicted on federal civil rights charges. So that's like another kind of path. But in terms of like criminal options for Derek Chauvin, if he's found not guilty, that's kind of where we end. I see Laurel also has this other question in the chat about what are the implications between this trial, Derek Chauvin's trial, and the trial of the other 3 officers. And kind of as it was stated in the video, you know, in our criminal legal system, each person is considered innocent until proven guilty. And because these trials are separated, the 3 other officers are going to have that same assumption of innocence coming into the trial. So regardless of what happens in the Chauvin trial, they're supposed to have like a fair trial. Now, there could be some things that come up. It might be more likely for their defense to argue a motion to change the venue. Perhaps they might have a better argument to say, you know what, since this summer, since whatever happened in the Chauvin trial, it would be really hard to find a jury that can be impartial in Minneapolis as a result of that ruling. So perhaps they might have a little bit of a better chance of moving the location of their trial, but they're like set to go in August, kind of no matter what happens in the Chauvin trial.
I have one quick question. What is the estimated timeline for this trial? I know it can take a really long time, years at times. So any kind of predicted timeline?
Yeah, that's a great question. So folks in our office have a little bit of a wager on this, but they're thinking somewhere between like 5 to 6 weeks. Essentially what we can expect moving forward. So next week, we'll hear opening statements from both sides. And this is their chance to really share their theory and kind of preview the jury of what will be coming for the next few weeks. The state goes first, and they have time to present their evidence, present their witnesses to comment on the evidence. And just given kind of what we've seen in terms of who they've submitted as potential witnesses, what evidence they want to introduce, we're thinking that that'll probably take about a week and a half to 2 weeks. And then the defense gets as much time as they need, but probably a similar amount of time. The kind of unknown piece here is jury deliberation and how long that will take. It is very rare for jury deliberation to really take more than like 2 or 3 weeks, but it is something that could happen as the jury's trying to come to a unanimous decision. So I think kind of adding that all together, we're thinking somewhere between like 5 to 7 weeks. So probably having a verdict come through middle to end of May. And a question, like, why is it so short? Why do some take years and this may not? And really the answer to that question is because it has been like an accelerated process in all of these pretrial hearings. So often the reason why cases can take so long is that there are like a ton of hearings before a trial happens. For the Chauvin trial, that started like back in July when he was first in court to hear his what the charges were against him, and they've been coming back to court on a regular basis. And in these pretrial hearings is where both sides are presenting what evidence they want to bring into the trial later. They're talking through some of the like conditions for the trial and things like that. And in a typical criminal case, that sort of thing can take a really long time. Often, there's additional evidence that needs to be gathered that can take a while to get access to, additional concerns about competency or whether or not someone's able to be there. But in this case, both sides, I think, have a pretty vested interest in moving this along. And the Judge Cahill, has been like super on it about like making the trial continue to happen. So I would say that though trials can take a very long time generally, it's often like this pretrial part that we've been experiencing as a community the last few months before getting to this point. But that point of like presentation of the evidence and that sort of thing typically is around that 3 to 8 week timeline. Why is this process in person? I know that other courts like immigration, it's virtual because of COVID. Yeah, that's a big thing that attorneys in our office are dealing with right now. In Hennepin County, since the beginning of COVID, essentially they've only been doing virtual hearings for, or they've been doing virtual hearings for everything except for cases where a person is in custody. They were like, I guess, maybe in early November, they had started transitioning to a few things in court, in person, kind of socially distanced. But then we had that like very scary second wave and they moved back to virtual. I think that there are arguments on both sides for the importance of having like in-person trials and in-person court. Attorneys in our office have been arguing like since the beginning of the pandemic that our clients haven't had their fair chance in court because they haven't been able to like stand physically in front of the judge to be able to like have some of those interpersonal dynamics that can only happen when we're in physical proximity to other people. And so for that reason, I think it is actually like a good thing that they're having this trial in person, and that, you know, like a family member of Mr. Floyd's family can be in the courtroom and like that can be a part of the atmosphere of the court. But it does like raise this question of like, who is more important? What cases are more important? There are very, you know, there are many people in our court system right now in limbo in Hennepin County Jail, also charged with like serious felonies, who also deserve that same chance for justice. And so I think that maybe part of the answer to that too is like, the court system is really concerned about this trial seemingly being very fair, so that community potentially can wrestle with the outcome of the trial a little bit easier. Okay. So a couple of things that I might be able to lump together here. So what do we know about Judge Cahill and their history with similar cases? The folks in our office have a love-hate relationship with Judge Cahill, but they see him as like a judge who, in the ways that other judges have like their particular mannerisms or like are very predictable people. I've heard lots of positive talk about Judge Cahill and the fact that he is like serious about like listening to merits of each case. And we've seen that in these pretrial hearings as he has like given space for both the prosecution and the defense to present their the potential evidence that they want to bring into the case and the witnesses that they want to bring as well. And so do we know if there will be witnesses? Yes. Who are they? I can drop into the chat in just a minute here. The Minnesota judicial system actually has a public facing website with all of the information of like all of the motions that have been filed in the case, things like that. And so you can pull up the evidence list that's there and the list of potential witnesses as well. It's a long list. I'm not sure exactly like how many people will actually end up being called into court. But what has happened in the last few months is that both sides have been arguing about like who should potentially be allowed in. And it's a long potential list. And that also then connects to this question around the 2019 arrests of Mr. Floyd and how that information in comparison, the information about Derek Chauvin's previous history will be introduced in the court. So there is a body of like judicial precedent and like rules related to how evidence can be introduced in the case. And what Judge Cahill has been really focused on in last week related to the previous arrest record, as well as in the last few months, is a specific rule of evidence called 404B, which I can also send a link to some more information about as well. But 404B says that one side can't bring in some other persons, so it could be the defendant or like any of the other like important characters in the case, can't bring in their past history in order to prove character. they could potentially use past history to prove motive, like willfulness, things like that, but can't use it to prove character. And so what Judge Cahill has said is Derek Chauvin's like history, like documented history of doing this exact same thing, using that sort of knee on neck hold, is actually more of an indication of character and not specific at all to like what happened on May 29th. So he said that that information could not come into the courtroom. On the other hand, though, the defense has been and was successful in getting some evidence about a 2019 arrest that Mr. Floyd had and bringing some of that information into the courtroom. Last Friday, Judge Cahill ruled that information about Mr. Floyd's physical characteristics and responses during that stop could be brought in. So how he handled that previous arrest physically could provide some helpful evidence potentially for the jury to make a determination about like what happened in May of this past year. But other information about his like mental status or emotional state couldn't be allowed in because that would be potentially talking about Mr. Floyd's character. I think a lot of folks have been really sensitive, and rightly so, to the fact that like Mr. Floyd is not the person on trial here. And we will, especially in our office too, be like watching to see the way that the defense makes their case, and observing the ways that they potentially are going to try to say, you know, Mr. Floyd was his own cause of his death because of his drug use, because of his previous medical conditions. Sure, Chauvin put his knee on his neck, but actually what killed him was like both resisting the arrest and then his physical body. And there's like a fine line there, maybe like less than fine, like a really thick line there between showing like whatever Chauvin did versus Mr. Floyd was the cause of his own death for here. I'm wondering how much more time we have for questions because I see a couple more good ones here.
Yeah, I think we can do one more,
Okay.
and then we'll move into breakout rooms.
Yeah. Okay, so I'm going to combine a couple of these questions about settlements. So I see Edgar's question, if the federal charges take effect, will the current process be discontinued? And the answer to that question is no. So if the grand jury that has been pooled does decide to indict Chauvin on civil charges, that's a totally separate process than the criminal process. And it's actually not uncommon that those things will happen parallel in criminal cases if there's a civil case looming. And so kind of how did the settlement case between the city of Minneapolis and the Floyd family impact this criminal trial? In some kind of significant ways. Judge Cahill has been really vocal. There have been a lot of advocates in community who have been really frustrated with the city of Minneapolis for deciding to announce this settlement in the middle of jury selection. And as a result, two of the formerly seated jurors were brought back. Well, all of the formerly seated jurors who at that time were on the jury, so I think that was like 7 people at that time, they were brought back in for re-questioning, and 2 of them were dismissed because they were asked the question, does the settlement change your ability to be impartial? So, I mean, that could be a big thing. We don't know. We don't know how those 2 people would have heard or deliberated on this trial. But that has been like a running part of questioning in the last, I guess, few days since the settlement has come through, because jurors don't have to be without context. They're not being, if you were able to watch any of jury selection, it is no assumption that they like haven't watched the video at all or, know about who Derek Chauvin is, but they have been asked to and are being tasked with taking this case at merit, like being able to impartially listen to the arguments made by the state and the arguments made by the defense, and just focus on that information. And so for folks who, saw that civil settlement potentially as a sign of like clear wrongdoing that the city is trying to combat, then I think well, that's the reason why they were released from the jury. I will say that I rambled through a lot of stuff really quickly, and I'll plug this again at the end, but tomorrow at lunchtime around noon, we are having an Ask an Attorney session with two of my good friends, Nick and Josh, who will be here to answer any more of these questions, go back in depth about things that we just talked about. So I'll share that information in the chat towards the end, but yeah.
We will also be sending out the link to all the videos. So we only played one of the videos here, but Malika has done a ton of videos about the trial and about the different processes that are going on. So you can always reference those as well if you're not available tomorrow at lunch. So we are going to head into breakout rooms to do some restorative processing circles. Malika, do you mind explaining a little bit about what these circles are? I'm sorry, you just finished talking, and then we'll move into the circles.
No, it's so good. I'm so glad to be able to set some context before you go into these spaces. As Ava mentioned at the beginning, the Legal Rights Center for 50 years, the majority of our work has been in criminal defense. But we also, in the last 10 or 15 years, have really leaned into our muscle around restorative practices and using different sorts of restorative practices, specifically like circle practice, as a tool for building community, repairing harm when it needs to be. So I'm excited to sit in circle space with whoever's in my small group. We've at the LRC have developed some tools for community members who are looking to use a discussion format in order to process what's been happening in the trial. And so we're going to have this opportunity together with folks you may not know, some folks that you do know, to share your thoughts and opinions on what's been going on.
Yeah. So we do have facilitators in each of the rooms that will be helping you out. Some rooms are going to have more than one facilitator to help you out going through this process. But I will go ahead and open up the rooms. Welcome back, everyone.
Just so many thanks to the team that put this together and shared this process. I know we did a kind of lightning round version of it, but even in that, I could see the potential and the power of bringing groups of people together to talk like that, and have these kinds of conversations. Just really great to be a part of it.
Yeah, thank you guys so much for participating, all of you. This is all available on the Legal Rights Center website through their Restorative Justice Toolkit. So we are hoping that you take this with you and bring it to other communities and hopefully do some more restorative processing as the trial continues and as we get into having a verdict. I am going to share with you quickly a word cloud of all the communities that we are a part of. So this is based on what you responded on your forms. So hopefully all of these communities are touched by what we talked about today and that you can bring this to another community. Our facilitators were all trained very quickly yesterday. So you can be trained too by just looking at that Restorative Justice Toolkit and using that to start a conversation in your own community, whether it be specifically in a restorative processing circle or just starting conversations with other people that you know. And then I just have a few more things to share with you before we close out. So as I said, the LRC does have that restorative justice toolkit that you can use on their website. They also have all those videos that we talked about at the beginning and the Ask an Attorney session tomorrow that you can attend if you have more questions. We also at the CCEL have a Ways to Social Change page. And a lot of this month's theme, which is Learn, is focused on the trial. So you can look there The U of M also has a page collecting all the events that are going on at the U in relation to the trial. Does anyone else have any other resources that they want to share with the group?
I put in the chat, the Cincinnati Public Radio had the Democracy in Me, What Does Justice Look Like? Education Outreach website, which really has some awesome YouTube videos and poetry by young people and pictures. And Michael, what you just shared was definitely shared by all the kids that that I took a look at in their videos and artwork, and is what we need to be asking ourselves. So I just wanted to share that with you. Oh, and Malika, you shared the UN Judicial Branch. We'll include that in our follow-up email as well, that we send out. Yeah, so thank you.
Yeah, if anyone else has any resources that they want to send to me, I'll send out that follow-up email tomorrow. So if you have any resources, please send them to me tonight so I can include them on that email. Just specifically for people who are in the CESP Scholars Program, if you are looking to use this for a collaboration and community building reflection, go ahead and shoot cesp@umn.edu an email so that I can send you the reflection for this. And I think we're going to direct most questions to tomorrow's Ask an Attorney session, but Malika will be here for a few minutes afterwards if anyone has any quick questions. And I will also be sticking around if anyone has any questions for me. Okay.
And thank you everyone for joining us this evening, and big shout out to the Legal Rights Center and Malika for your support in pulling this together, and thank you facilitators. Do think about how you can bring this to your own communities. We have a while to go yet this summer, and have a feeling we're all going to need restorative processing time. Thank you
So much. Have a good night.